So the feds, they are pissed, bruh. The feds is hot. They damn near called Drew Fillon and his whole firm basically some busters, some liars, everything under the sun except their goddamn names. Let's get into it. I'm gonna get through the first 7 because I ain't gonna hold y'all. If you are drinking or eating anything, stop right now because this about to be funny as hell. Obviously, he's no longer he no longer boss man. I just want y'all to know that. So it says government's initial response to defendant's motion to disqualify all prosecutors and judges in the Central District of California because they had to clap back, bruh. That damn that damn that letter that they put out, bro, it was pretty bad. Plaintiff, United States, we don't care about none of that. Let's just get right here. This filing is based upon the attached memorandum of points and authorities, the files and records in this case, is such further evidence and argument as the court may permit. So let's go through. The government files this initial response to defendant's motion to immediately correct factual misrepresentations in their filing, meaning y'all lying on us. Imagine the feds calling you a liar based on 4 voice messages and a threatening phone call made by apparent supporters of Durk Banks and Wilson. So now they're supporters, right? So now they're not killers. They're not any of that stuff. And this is how the feds operate. It's just funny as hell. Threatening phone call made by apparent supporters of defendant Banks and Wilson, none of which were made to this court. The defendants seek the extraordinary remedy of dismissal of this murder case and disqualification of every prosecutor and every judge in the district. The motion lacks merit and should be denied, which the government will address in an opposition that will be filed on December 1st, 2025. Defendants also seek an extraordinary procedural mechanism to address the motion that none of the over 35 district court judges in the Central District can hear this matter, and that it should be referred to an out-of-district judge, as discussed below. The court should reject that request, and all is well established for 455 motion, rule on the motion. As discussed further below, the government respectfully requests the following. First, the court should rule on defendant's motion and deny it on the merits after the parties have fully briefed the matter. Second, the court should not vacate any dates in this case, including the trial date. Defendants have not asserted that they need additional time to prepare for trial, nor have they otherwise requested a continuance. The government and the murder victim's family object to any continuance or vacatur of the trial date based on this motion. On its face, the motion fails to state a basis for this court to recuse. Actually, that's not even true. They literally point to whatever happened in Oregon, so you're lying. As a threshold matter, the motion incorrectly represents the party's request that the court refer to this matter to an out-of-district judge for hearing as soon as it is practical or practicable. Black letter law establishes that district judges routinely evaluate recusal motions under 28 U.S.C. 455, including these involving far more serious threats and threats specifically directed at preceding judge. See Bernard, basically. The somewhat surprising and not entirely comfortable, shut the hell up. Reality is that the 455 motion is addressed to and must be decoded by the very judge whose impartiality is being questioned. Section 455 includes no provision for referral of the question of recusal to another judge. If the judge sitting in this case is aware of grounds for recusal under Section 455, that judge has a duty to recuse himself. We, along with our sister circuits, have identified various matters which will not ordinarily require recusal under 455, including threats or other attempts to intimidate the judge, cleaned up in R.E. Bassarino, I don't know, affirming district court's decision not to recuse based on defendant plotting to kill judge, a prosecutor, and cooperating witnesses. At bottom, defendant's motion fails to state any basis or supporting citation for this court to refer the motion to another judge, much less a judicial officer outside the Central District. The threats by defendant supporters were not directed at this court, and even if they were, the court will still appropriately evaluate the merits of the request for recusal. Basically saying, hey bro, if this was really a thing, y'all not sending this outside of the damn court. We gonna hold ball right here, which is insane because they're essentially saying the judge that's looking over this has to say, oh yeah, I'm being biased. And we've seen what happened with Glanville. So this is some cold bullshit, but it is what it is. Defendant's motion rests on factually inaccurate claims about purported ex parte communications between the USAO and the court. The court should also reject defendant's request to refer the matter to an out-of-district judge because this court is best positioned to address defendant's factually inaccurate claim about purported ex parte communications. Defendant's request is based on the untrue assertion that the United States Attorney's Office, in carrying out a secret investigation, relayed the threats to all judges in the Central District of California, including this court. Notably, defendants provide no citation to support this claim. They cannot because it is false, inflammatory statement that has no factual basis. As this court is aware, the United States Attorney's Office did not inform this court about the threats to the magistrate judge or AUSA or otherwise engage in substantive ex parte discussions between the bench and the prosecution about threats directly implicating defendants. Indeed, the email correspondence attached to defendant's motion shows that the USMS informed Chambers about the threats to the magistrate judge. Moreover, so you just said that you're saying that they got goddamn informed anyways. That's right there. Moreover, undersigned counsel are also unaware of any correspondence from the United States Attorney's Office informing this court, much less all judges in the district, about the threat to AUSA. For these reasons, the factual basis for defendant's claims that an out-of-district judge should hear this motion is unsupported, and this court is best positioned to evaluate the merit of defendant's other contentions. Conclusion. As the Ninth Circuit has explained, we regretfully live in a time when threats against federal judges are not uncommon, where many of the actions are made with the intent of alerting the outcome of judicial proceedings. Denying writ to disqualify all judges in the Central District of California were defendant charged with threatening 3 district judges in the district. Man, come on, bro. So you're literally saying that, 3 judges got threatened, but this one didn't, so he could hear it. They literally say in the damn motion, bruh, y'all think that if you threaten my homie and y'all find out about it, you're not going to hold some type of thing about that? That's what the motion was about. The defense is lying again. But the court emphasized that we must be especially careful not to allow threats of violence to succeed in altering the normal course of litigation, as to do otherwise would be destructive of the independence of the judiciary. The government respectfully requests this court deny defendant's request to refer the motion to another court. The government and the victim further oppose defendant's attempt to delay their trial based on this motion. So this is how genius the motion actually is, because the feds are terrible. What they said was basically, you can't sit up here and say that we have threats and it only went to 3 freaking people. The feds just said we investigated this and this ain't nothing but some Durk supporters. So there was no actual credible threats. It doesn't say these are gang members that came after him. These are people capable of murder. It basically say crazy ass fans came up. They wanted to threaten judges and all of this stuff. We evaluated it, code level 0 out of 10. So y'all just admitted that there was no real threat. So when y'all say outside sources or these vague ass words, you know you're lying. You know you flat out lying. So what they're saying is this. The internet has decided to say, we know who are the witnesses. I'm not going to say who I believe the witnesses are because 1, I ain't trying to get snatched by the feds again. 2, by y'all cats doing this, anything that happens to anybody, that's on y'all. Make assumptions all you want to, but please know that if anything happens to anybody, the feds are coming to talk to everybody. Just gonna say that. So y'all can believe it's whomever, whatever. It just is what it is. I would get off the theory, if I'm anybody, I would get off the theory of who I believe it is. Y'all can point to certain things of what people said and all that and say, I don't know why he would say that. y'all better proceed with a lot of caution. That goes to all bloggers. Number 2, or number 3, I think it is, right? Anyways, the way that this is shaping up, and I'm just going to be fair, it's not getting thrown to another court. The judge has to make the decision about whether to recuse themselves. I'm sorry. Drew, is a good chance. It was a good shot, but that shit ain't going nowhere. Because to me, they're saying, hey, judge, you weren't goddamn threatened. So no, keep it here. And the judge who is going to hear it is ultimately the judge who decides to recuse themselves. Now, here's the funnier part. Just gonna be fair. If they do happen to do it, where is it gonna go? Like, what court you think? You better hope they ship that shit up north. Because if it go to the right of the map to Arizona, you screwed. But don't, shit, Arizona, whatever federal district court Arizona has, if they have one, you better hope not. Nick, hey, Arizona was the last goddamn state to give Martin Luther King a damn holiday. Like Martin Luther King, who preached if these dogs and these fire department cats with these hoses keep hitting us with all this shit, we ain't gonna do nothing but pray about it. The most non-violent man in American history. They say he didn't even beat his kids, he just gave them an hour lecture. I have a dream that you will sit here, read these books, Martin Jr. III, and make sure you go and clean up and take the groceries with your mother. Go fishing in a pond. Make sure that you have your Sunday's best done by Friday. I am telling you this because, Martin III, you will one day be a man, and you will have kids, and you will not be... Nah, I'm playing. Let me stop doing that, because some of y'all probably pissed. He's making fun of Martin Luther King. He can't do that. I just did, homie. Shout out Martin Luther King, though. I mean, he got his holiday, so... And he got like 3 bills passed right out there. Fair housing, civil rights, and voting rights act. That's pretty damn powerful. For all. Not just black, by the way. All you Hispanics, Asians, and all that, y'all better be thanking Martin Luther King. That's why Cesar Chavez is the way that he is. Shout out. Anyways, so you have that, but not only that, the government decided to say, oh, hey, it's on you, Judge, to decide this. Now, this one is one I've been waiting for because we all have been waiting with bated breath on this one. So this is government's notice of lodging under seal exhibits 1 through 6 in supplemental memorandum in opposition to defendant Durk Bank's motion to dismiss for vagueness or in the alternative for a bill of particulars, plaintiff United States of America, whatever. Let's just get into it all the way. So, memorandum appoints and authorities to assist the court in resolving defendant bank's motion to dismiss for vagueness for a bill of particulars. The government hereby lodges under seal exhibits 1 through 6 defendant bank's reply in support of his motion to dismiss for vagueness or for a bill of particulars. Docket 286 claims that nowhere does the discovery set forth anything resembling a fixed or coherent theory of the time, place, and circumstances of the bounty allegations or at the direction of allegations. The statement is not true. For example, the government has produced discovery that explicitly states the time, place, and language used to convey the bounty to at least 2 different witnesses. The discovery produced to defendants also explicitly states multiple examples of defendant banks directing his co-conspirators to take actions in furtherance of the murder scheme. To the extent defense counsel believes these statements do not resemble a fixed or coherent theory of this case, they have the right to present them to a petty jury. For the reasons set forth in the government's previously filed opposition, the court should deny this motion. Yeah, okay, feds. Okay. All right. Us and the family of the victim. One, shout out to Lil Pop's family. Just is what it is. What happened, in my belief, shouldn't have happened from beginning to end. I wish there was a way that, obviously, these dumbasses with money, power, influence, bullets, drugs, and liquor could always come to a common ground of let's not go to jail for the rest of our lives and let's not kill each other. What's the other compromise? But to the government, I just want to ask this question. If your case was so solid, right? If everything y'all had is so solid, right? And y'all accusing Drew of lying, right? Why the hell did y'all have to come up with a second superseding indictment? Not only a second superseding indictment, y'all had to come up with a damn Fed edit video that y'all said came out afterwards. You guys have been caught lying a dozen times in this goddamn murder for hire plot with Durk Banks and the OTF members that y'all say. You guys are lying flat out. So the Stefan Mack murder, you guys are lying in that one for sure. You guys are lying about the damn shooting that had happened anyways, because for all your great investigative skills, you don't have anybody. You have two witnesses that are telling you stories, one who has a life sentence. Y'all grasping for straws. You know y'all more than likely got the other cats. But it's like, let's get the money out of here. And I don't think anybody flipped. This is the same language that Fonnie Willis has to use. And then when I had said this shit, everybody was like, you ain't right. Damn, he is right. Shit. So there you have it. The feds are basically said, Drew Phelan, you and your team are a bunch of liars. The feds already been caught for lying. The judge who's going to hear this is not going to kick the case to somewhere else because he doesn't have to. But the case law that they get out of the feds in Oregon is pretty damn good. Pretty damn good, bro. I ain't gonna hold you. The way that they have it set up, one could say, one could argue, Judge, you should recuse yourself. Because 3 of your homies got told they gonna get spun on. But the feds even admitted these weren't nothing but Lil Durk fans. So what else have you been hiding? And that's where the feds just failed and they goddamn shit. Because you said, hey, Judge, Lil Durk is dangerous. He got people that's threatening judges. He got people that's threatening district attorneys. Oh, these are fans. What is fan short for? Fanatic. Did you blame John Lennon for the damn fan that smoked him? No. These are fans. These are people who at times don't understand what the hell they're doing. And why didn't y'all arrest these people? Oh, because it would have proved exactly what Drew said. Y'all making this shit up as you go. But let me know your thoughts. Maybe I got it wrong. Maybe. But click right here to see how Drew Phelan basically said, I'm choosing this case we talking about over Rod Wave. And Rod Wave is one more strike from actually losing. Let me say this again. One more strike away from losing Drew Phelan. Click right here to find all of that out. And I'll catch you on the next one. And for y'all saying, Ceddy Nash, you're not in Puerto Rico, bro. Listen, man, I don't need to lie, bro. I don't need to lie about nothing. Y'all see this shit? I don't need to lie for what? What would I need to lie about? Ocean views, small circle. It's a chosen few. But click right here, or click right here for the playlist.